Hello, welcome to the Family Law section of the ULV Justice Center website. Glad to have you. In this video, I will be covering how to open a dissolution, legal separation, or annulment case, and how to complete the preliminary financial disclosures. Before I get started, I want to remind everyone that the information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise that you consult with an attorney. As previously mentioned in the video under the divorce, legal separation, and annulment page, the petitioner is the person that opens the case by filing a petition. The respondent is the person that responds to the petition by filing a response. When first opening a case, the petitioner needs to have the respondent personally served with notice of the lawsuit. The respondent is not required to personally serve the other party with their response and can instead mail their response to the petitioner. I will first go over the forms that the petitioner fills out. The petition is the form that opens a case. On this form, you will give the court some basic information about your marriage or domestic partnership, and you can ask for orders that you want the court to make. If you need more room on your petition to list your property and debts, you can use the property declaration form. This form will ask you to list all of your property and debts, the date the property was acquired, the gross and fair market value of the property, whether there is a debt owed for the property, whether the property is community or separate property, and it will ask you to give a proposal for division of the property between the parties. The summons for family law contains important information for you and your spouse about divorce and legal separation. It contains some standard restraining orders limiting what you can do with your property, money, assets, and debts. It also prohibits you or your spouse from moving out of state with your children and from applying for a new or replacement passport for any of your children without the prior written consent of the other party or a court order. If you and the other party have minor children together, you will also need to fill out the form titled Declaration under Uniform Child Custody, Jurisdiction, and Enforcement Act, also known as the UCCJEA. This form is meant to help the court establish whether they have jurisdiction over the children from the marriage or domestic partnership, so that the court can make enforceable orders regarding child custody, visitation, and support. This form will ask you to list all minor children from the marriage or domestic partnership, their birth dates, their place of birth, their gender, where the children have lived for the last 5 years, and who the children have lived with for the last 5 years. If the children lived in different addresses throughout the last 5 years, you will need to include all of these addresses. You may also be required to file a case cover sheet depending on what county you are filing in. Every county has different requirements, so it is best to check with the court clerk to verify whether you need to submit a case cover sheet as well. The next step for the petitioner is to have their forms reviewed, make 2 copies of their forms, and file them with the court clerk. The petitioner may want to have their forms reviewed by an attorney, the court's family law facilitator, or the court's self-help center. Once the petitioner is satisfied with their forms, they will want to make 2 copies. When filing documents with the court clerk will keep the originals and stamp the 2 copies. These copies are known as conformed copies. 1 copy will be served onto the other party, and the other copy is for the petitioner's own records. Once a case is opened, the petitioner will need to have the respondent personally served with notice of the lawsuit. If the respondent is never notified of this lawsuit against them, then the court has no jurisdiction over them and cannot make enforceable orders against them. The petitioner cannot personally serve the respondent themselves because they are a party to the lawsuit. Therefore, they will need to have a friend, process server, or a sheriff serve the respondent. A server must be 18 or older and not a party to the lawsuit. If the server has diligently tried to serve the respondent personally, but has been unable to, they can do substituted service. A minimum of 3 attempts to personally serve the respondent at different dates, times, and locations may be considered due diligence. Substituted service is when the server leaves the summons and petition with someone else at the respondent's home or workplace. The person who receives the summons and petition must be 18 or older and either lives at the home or is someone who seems to be in charge at the respondent's workplace. The server must tell the person that is receiving the documents that they are legal documents for the respondent. The server must also write down the name and address of the person he or she gave the court papers to. If the person will not give his or her name, the server must write down a detailed physical description. The server will then fill out and file with the court a proof of service of summons. This document lets the court know when and how the respondent was served with notice of the pending lawsuit against them. Once the respondent is served with the petition, they will only have 30 days to respond. If the respondent misses this deadline, the petitioner can request to enter default. If the court grants a default judgment, then the respondent will have no say in the case, and any orders the petitioner asked for in their petition will most likely be granted. If you are the respondent, you want to make sure you do not miss this deadline. There are several things a respondent can do when receiving notice of a lawsuit. They can either not respond and do nothing, not file a response but have a written agreement with the other party, file a response with the court but also reach an agreement with their spouse on all issues, or file a response and disagree with what their spouse is asking for. By not responding and doing nothing, the respondent is forfeiting their right to participate in the case. With the second option, the case is considered a default because the respondent did not file a response. However, by having an agreement with their spouse, the respondent still has a final say with the outcome of the dissolution or legal separation. With the third option, this is considered an uncontested case because the parties are not fighting over the issues and are agreeing to the terms of the dissolution or legal separation. With the last option, this is considered a contested case because the parties do not agree to the terms of the dissolution or legal separation, and the court will need to make decisions for them. If the respondent decides to respond to the petition, they will file a response and a UCC-JEA if the parties have minor children together. Similar to the petition, the response asks for basic information about the marriage or domestic partnership. It also allows the respondent to respond to the petitioner's requests and allows the respondent to ask for orders that they want the court to make. Similar to the steps previously mentioned for the petitioner, the respondent should also have their forms reviewed and make 2 copies. Once this is done, the respondent will file their documents with the court. The court clerk will keep the originals and return the stamped copies to the respondent. 1 copy will be served onto the petitioner, and the other copy is for the respondent's own records. Unlike the petitioner, the respondent does not have to personally serve the petitioner with notice of their response, but can do so if they wish. The respondent can have the petitioner served by mail with their response. The server must be someone who is 18 or older and not a party to the lawsuit, such as a friend or a process server. Once service is completed, the server will fill out a proof of service and file it with the court. Depending on the manner of service will determine what proof of service the server will fill out and file. There is a proof of personal service and a proof of service by mail. Once a case has been opened, the next step is for the parties to exchange their financial disclosures. Even if the parties are separated, they still have a fiduciary duty to one another until a final judgment has been entered. A fiduciary duty is a duty to be fair and honest with the other party regarding all business, investment, and income-producing opportunities. If a party is found to be dishonest, their property can be transferred to the other party, and the dishonest party may face sanctions. Typically, the parties will be required to do a preliminary declaration of disclosure and a final declaration of disclosure. The parties can agree to waive the final disclosures, or if the case is a true default, the petitioner can waive the final disclosures. If the respondent does not file a response, they are not required to complete a preliminary declaration of disclosure. The petitioner is required to do the preliminary declaration of disclosure and cannot obtain a judgment for dissolution or legal separation without doing so. Once a petitioner has opened their case, they will have 60 days to serve the respondent with their disclosures. Once a respondent files a response, they will also have 60 days to serve the petitioner with their disclosures. However, preliminary disclosures can also be served onto the other party concurrently with the petition or response. The forms that are required for the financial disclosures are the Declaration of Disclosure, the Declaration of Service of Disclosure, a schedule of assets and debts or a property declaration, an income and expense declaration, and a statement of all material facts and information regarding all assets that are community property, all obligations that the community is liable for, and any other income-producing opportunities that have been presented since the date of separation. The material facts should be put on pleading paper, which I will show an example of later. The Declaration of Disclosure lets the other party know what forms and attachments are part of the financial disclosure. The Schedule of Assets and Debts and Property Declaration ask you to list all of your property, the date that property was acquired, the value of that property, whether there is any debt owed for that property, any other debts that are owed, and to distinguish whether that property is separate or community. Separate property is property that was acquired before the date of marriage and after the date of separation. Community property is all property that was acquired during the marriage and that both parties have equal ownership in. Gifts and inheritance are an exception and are not considered community property, even if they were acquired during the marriage. The income and expense declaration asks you to list your monthly income, the source of your income, who lives with you and whether they contribute to your monthly expenses, what your monthly expenses are, and to list any additional expenses related to your minor children. All of these documents and your necessary attachments will not get filed with the court and are only served onto the other party or their attorney if they are represented. The only document that is filed with the court is the Declaration of Service of Disclosure. This form is like a proof of service and lets the court know that you serve the other party with your financial disclosures. As I previously mentioned, you will need to serve the other party with all material facts and information regarding your assets, obligations, and income-producing opportunities. This is an example of something you can do if you are not aware of any material facts regarding the valuation of community assets, any community obligations, or have not been presented any other income-producing opportunities since the date of separation. Make sure in the title to include whether this disclosure is the preliminary disclosure or final disclosure, the last name of the parties, and the case number. In addition to these forms, there are other attachments that will need to be included and served onto the other party. These attachments include all tax returns filed by the party 2 years before service of the disclosures, pay stubs from the last 2 months before service of the disclosures, or a profit and loss statement from the last 2 years if you are self-employed, and any other necessary attachments depending on what property the parties own together. Remember to black out your Social Security number on all pay stubs, tax returns, or any other documents where your Social Security appears. You should also black out all account numbers when attaching statements. In this example, I took a screenshot of the Schedule of Assets and Debts form. You'll notice that next to where it says real estate in parentheses, it says to attach copies of the deed with a legal description and the latest lender's statement. In contrast, next to where it says household furniture, furnishings, and appliances, it only says identify, meaning you do not have to attach anything for that particular property. Pay close attention to these forms because, though it is not obvious, it will tell you what attachments must be included. If you are having trouble locating these forms or need assistance with filling out these forms, you can copy this link into your search bar. With this link, you will have access to the forms you will need to open your case, to do your financial disclosures, and you can even have your petition prepared for you. This has been an overview of how to open a dissolution, legal separation, or annulment case and how to complete the preliminary financial disclosures. On behalf of the ULV Justice Center, we thank you for your time and hope this information is helpful in your legal matter.